I want to welcome you to this meeting number 27 of the House of Commons Standing Committee on Access to Information, Privacy and Ethics. Conformément à l'article 108.3.
Pursuant to Standing Order 108.3H and the motion adopted by the committee on Thursday, February 5th, 2026, the committee is commencing its study of the state of access to information in Canada.
I apologize for the late delay, but we just had votes, so I would like to welcome our witness for today from the offices of the Information and Privacy Commissioners of Canada, Caroline Maynard, the Information Commissioner of Canada. Ms. Maynard, you have up to 5 minutes to address the committee with an opening statement. Please go ahead.
Thank you for the opportunity to once again appear before this committee to talk about access to information. I understand that the committee wishes to focus on two areas today: the use of instant messaging and information management within the public service, as well as the performance of the Privy Council Office, PCO, in the area of access to information. J'aimerais commencer par clarifier
I would like to first clarify some information management responsibilities. The Treasury Board of Canada Secretariat establishes information management policies for the Federal Public Service. Library and Archives Canada, however, is responsible for establishing the retention and disposition authorities that govern how federal institutions must manage, preserve, and ultimately dispose of their records. Each government institution must then set its own information management practices, including those governing transitory records.
Some aspects of records management do become relevant to my investigations the moment an access request is made to institutions that are subjected to the Access to Information Act. I would like to point out that there is no obligation to create records under the Act. The Act only applies once a record exists in any form. This includes transitory records. Retention policies vary according to the type of record and can range from days to decades. Retention policies are a good and necessary thing for proper information management, but they must be accompanied by training and founded on some basic principles. Some of these principles are spelled out in the message I sent to institutions last week and provided to this committee ahead of time. I hope you have had the opportunity to review this message. It affirms that records created using digital collaborative tools such as Microsoft Teams must be managed in a manner that upholds the right of access to information. Pour ce qui est du deuxième sujet que je souhaite aborder.
Turning to the second topic, let me start off by saying that the order-making power is a key tool at my disposal. Orders enable me to conclude complaints that we have been unable to resolve by other means. I would like to highlight some statistics on orders in the handout I provided to this committee, which tell an important story. It is interesting to note that while the Department of National Defence and Library and Archives Canada have received the most orders so far since 2019, in the case of both institutions, the number of orders I have been required to issue is declining. Unfortunately, the data shows the opposite trend with respect to PCO.
The Department of National Defence and Library and Archives Canada shows how institutions can improve their performance when they address the issues that have resulted in orders. Timeliness tends to be the greatest challenge to transparency at PCO and has resulted in a high number of orders to respond to late requests. Good information management practices include transferring records of archival value to Library and Archives Canada in a timely manner. However, PCO continues to struggle with a high volume of requests related to records that are between 35 and 69 years old. PCO's central role in the implementation of the government's priorities makes timely access to its information even more vital. Improving access to information at PCO presents an ideal opportunity to lead by example. C'est avec plaisir que je répondrai
I
maintenant.
will be happy to answer any questions on these or other topics you would like to address with me today. However, I cannot talk about any investigations as they are confidential. Thank you.
Thank you, Madam Commissioner, and I do appreciate you making yourself available today on such short notice. And I want you to know that on behalf of the committee, I want to say thank you for that. We're going to go to Mr. Barrett for 6 minutes. Go ahead, sir.
During the ArriveCan scandal, we heard variations of from public servants that, quote, we can't find the records. And when records disappear, this stops being an administrative issue and becomes an accountability issue. And so what we're looking at now is this question about business value versus what's transitory. Do you think that that approach works? Yes or no?
Yes.
And do you worry that when employees are being asked to flag what is a business value within 15 days, that there's a risk that the records won't be found, won't be easily found, and will more often lead to results in access to information requests that say no record exists, when in fact that, perhaps not through malice, but just simply through the act of trying to keep records, that it's going to make it harder for accountability to be brought to bear?
This is why I said that retention policies and proper information management policies are a good thing, but they have to be accompanied by training with strict directives. And as you just pointed out, access without a record, if there's no records, there's no access. But at the end of the day, we do, and I do support proper management of information. The uses of teams to make important decisions should not be allowed or encouraged. There's way to do that, and it would be the same thing as saying we cannot have meetings anymore or oral discussions. Those happen, but you have to have somebody at the end of the day, at the end of the meeting, taking minutes, explaining what was discussed, what were the decisions made, and how, and based on what.
Is there a greater risk to the integrity of the system and Canadians' confidence in their institutions? Look, at the start of the ArriveCan scandal, we were told there's absolutely nothing to see here. It turns out that it was the tip of the iceberg on massive contracting problems, and ultimately, in some cases, criminal charges were pursued. We have civil action being taken to recover the money. But we were only able to do that by piecing together records. So I haven't been presented with a compelling reason why these chats need to disappear after 15 days, but I can see a pretty serious downside with not having access to records if a decision is made or direction is given or a discussion is had that later would have value in having that accountability.
Just so you know, that when what I was saying earlier, when there's an access request, there has to be a mechanism to stop the deletion of any records, because those records, whether they are transitory or not, if they are responsive to the access request, they should be treated and processed. Whether the people are using Teams for other reason than just what they're supposed to be used, and it's like to quick conversation, not business-related activities. This is a matter of where the head of the institution needs to be very clear how these messages has to be used and managed and properly saved.
What would your recommendation be as a minimum retention period for Teams chats that include decisions or direction?
I think this is something that you need to talk to the Library and Archives they're the one responsible for setting some of the rules. And again, it really depends on the type of activities that are being used for these type of communications.
So, what metric do you track that proves that bad records management is hurting requesters? And are you able to tell us how that metric has changed over the past year?
Well, the fact that we're using now electronic documents, back and forth emails, people are not, even inboxes should be cleaned by people. There shouldn't be 5 people keeping the full communication of one email. There should be somebody responsible at the end of the day to save those emails in a proper folder, proper repository. It shouldn't be kept in inboxes in everyone's,
Right.
and that's one of the biggest issues that we have.
I have just under a minute left. So you have binding order powers, which I think is critical for any commissioners. This is crucial. Are institutions complying on time and more often with you now? And how often are you seeing that your orders are ignored without going to court?
It has happened a couple times. I think we have 8 mandamus that was presented in court to force an order to be respected. In the last year, I only had to do it once, and it's now, I think the message has gone through. Like, people are not ignoring my orders anymore.
Thank you.
Okay, thank you, Commissioner. Thank you, Mr. Baer. Monsieur Sarré, pour 6 minutes. Commencez, s'il vous plaît.
Merci beaucoup, Monsieur le Président.
Thank you very much, Chair. Thank you, Ms. Maynard, for being with us today. I would like for us to talk about this complex topic, and I would like to focus on 2 things. The first has to do with your recommendations. You mentioned 2 things having to do with timelines, and the second is increasing access to information. I would like to hear you on that for perhaps 2 minutes. You would like to know my recommendations for changing the legislation? Yes. Institutions are having a hard time meeting the 30-day deadline for an access to information request. That is because of internal consultations with other institutions, and one of our recommendations in the last 3 years to committee was that internal government consultations need to be legislated. There should be a limited deadline, because currently it's random and institutions are taking too much time to respond to these consultation requests. So that's one of the recommendations we had made, and the other had to do with the number of institutions that should be subject to the legislation, the Cabinet of Ministers, the Prime Minister's Office, institutions that are working on behalf of the government. So institutions receiving public funds to offer services to Canadians, these institutions should be subject to the Access to Information Act. Do you believe that expanding the list of institutions subject to the legislation would create more requests and create more delays when we are already struggling to respond to requests? Answer: each institution should have a unit focused on access to information requests. So they should have the adequate resources to respond to requests sent to their institutions. Every department, every institution, every agency should have a dedicated team. It's a quasi-constitutional right, and so I believe that Canadians need to have access to the information that belongs to them, and I agree with you on that. Would it not lead to public servants using other means of communication other than the type that is offered at government? Answer: this is a very relevant conversation. Our recommendation at the office is to stop the use of applications that would not allow these units to have access to documents or messages that are shared using those platforms. But again, it's a matter of training and having clear rules and guidelines. I've seen this before in my career. We can receive requests that are legitimate and interesting, but sometimes we can receive requests that are frivolous. And I've seen that in other institutions that I worked for, that there were more frivolous requests than relevant ones. Currently, the legislation includes measures for requests that seem to be made in bad faith or that are excessive, and institutions can ask me for the right to not respond. Chair, last week I said that we had received about 60 such requests. We had received, in fact, 80, and only 15 were accepted. So it is a small percentage where that request would be considered abusive or made in bad faith, but there is a proper process for that. On another topic that I hope is lighter, do you believe that integrating AI could simplify work and make deadlines shorter for these access to information requests? Answer, yes. I believe that if we have an adequate information management system and we add to that AI tools in order to remove any duplication and target relevant information, it would assist in responding more quickly. I believe that Transport Canada is a department that uses AI. Same for Immigration, IRCC. They also have systems in order to treat these requests more quickly. I don't have a lot of time left, and I would like to talk about the powers given to you in 2019 by the government. Can you explain it very briefly, because I don't have a lot of time? Has there been a positive impact on your work? Yes. Before, the office could only give recommendations. Now we can give orders. That's about 8% of all of our complaints, and it is a very useful tool for the office. Thank you, Mr. Sari. Mr. Thériault, you have 6 minutes. Thank you. Hello, Ms. Maynard. And thank you for being able to be here on such short notice. Access to information is a cornerstone in ensuring the vitality of a democracy and giving power to citizens. It works if citizens can have access to information. And for a few years, and I think that we had this discussion the last time you were here, but there seems to be a bit of a resistance. Institutions don't want to be proactive and get ahead of things. They wait for these requests to be sent in, and they're not organized in order to respond in a reasonable time frame. What explains that? It's very costly. Proactive disclosure is costly. That's what I'm told. But I believe that if documents are created by default, when decisions are made and when policies are created, we know that Canadians are going to want to understand it and ask questions. And so I agree. If there is more voluntary disclosure by these institutions, Canadians will understand better. They might not agree, but they will understand decisions made and actions taken, and they will have the tools to exercise their democratic rights. It is costly. That's what I hear. I also believe that there's a culture with government institutions. They are afraid of being questioned or criticized, and yet we're seeing that when the information that is given is reliable, it is positive, and institutions should use that. And if reliable information is not given, people will find that information elsewhere. They'll become curious, yes, but they'll be asking questions regarding whether or not they understand a decision that has been made. This leads to the spread of disinformation and misinformation, and if we want to fight all that, giving out proactive information and responding in a timely manner is essential. Institutions complain about disinformation, and so if we want to avoid any theories, people need to be informed. They need to have access to information, and we should promote proper information. That way, we'll have Canadians that will be able to make informed decisions. But in order to do that, and to avoid conspiracy theories, last September, there were people at Treasury Board who were responsible for access to information, and they stated that the government should review your order-making powers, and these powers were given to you in 2019 through C-58. Do you believe that you will be able to continue to protect Canadians? I understand. I don't know if I can call it rumors, but there have been talks about the risk of continuing with the order-making power, but I've shown the stats. We're talking about 8% of all requests, not even, 8% of the requests that end up on my desk are looked into and end in an order. So that's about 250 orders in the last year. This power allows us to conclude the process, and we have a goal, and that is that answers are given to the requesters. I don't think that we can go back on that and remove the order-making powers to these powers from the office. This is something that we can talk about when there will be a legislative review. This is something that we're still waiting for, but it is something that I am eagerly waiting for so that I can share my recommendations. Microphone, please. Treasury Board, in looking at the access to information legislation, would like to restrict Canadians' access. What would be best measures that could be taken to stop that? The legislation includes a mechanism to stop requests that are frivolous or vexatious. I don't think that we need to go beyond what's already in the legislation. Thank you. Thank you, Mr. Thériault and Commissioner.
100 seconds. Go ahead, sir.
Thank you, Mr. Chair. Thank you, Commissioner. The federal department or institution with the largest number of access to information complaints currently in your office's inventory is the Prime Minister's Department of PCO. Is that correct? Yes. Okay. Now, the number of orders you have issued to the PCO to comply with the Access to Information Act has gone up markedly, 0 for the first 3 years of your order-making powers, then 14 as of 21-22. A record was reached of 42 in 24-25, and already this year, 45 orders have been issued. Is that accurate?
Yes, sir.
And is it fair to say that the performance of the PCO with respect to its compliance with the Access to Information Act is of concern to you.
It is.
Okay. And to understand some of the issues, would it be fair to say that delays are rife?
Delays are what is the most concerning, yes.
And backlogs are growing?
The backlog, that's a different thing. For me, the inventory keeps going up.
Okay. And as a result of your concerns, you requested a meeting with the clerk of the Privy Council, Mr. Sabia. You wrote to him on July 15th, 2025. Is that right?
Yes,
And you met with him on November 12th, 2025. Is that right?
that's correct.
So it took him a full 4 months to sit down with you. Doesn't sound like he was in too much of a rush to meet with you, but in the course of your meeting, there is a backgrounder that your office had prepared on that meeting. And among issues that were discussed, in addition to persistent delays, was that, quote, with respect to access to information, quote, work that needs to be done to implement an order should and could have been done prior to a complaint being submitted. So is it the case that the PCO is sitting on access to information requests, not taking steps to comply with them until a complaint has been made?
There's a lot of complaints that we received that are have been with the office of the PCO for quite a long time, and those, you're right. There's a lot of work that can be done before it comes to my office.
And this is occurring frequently, just to understand.
Yes, if you go to my website, you'll see a lot of examples of orders and decisions that were rendered with respect to PCO.
And is it getting better or worse?
It is not getting better.
Okay. And in the same backgrounder on the meeting, you note that the PCO has a pattern, or has, at least on occasion, exaggerated claims of harm regarding why some documents were being withheld from requesters. Can you elaborate on that?
There's two cases that went to the court that was where the argument of harm was used for secret documents or top secret documents that were historical documents, like not current information. Old documents, like I said in my opening statement, we're dealing with some information that are within PCO still that are between 40 to 69 years old. And so, yes, the court finally, because it went to court, it was settled before a decision from the court.
The federal court, in one of those cases, ordered the PCO to pay $4,400 on the basis that it should never have gotten to court, that the PCO should have abided by your recommendation, which was to release a report in its entirety, correct?
Yes.
So they were slapped on the wrist by the federal court. Now, in terms of the meeting that you had with Mr. Sabia, did he undertake any steps to improve PCO's compliance with access to information?
He was very receptive.
But
we had a very good meeting. I have to say, I've met 4 different clerks in 8 years of during my appointment. Mr. Sabia was very receptive. He understood, had good questions, and didn't make any promises because but he definitely took upon himself to get more information and to help us
and
achieve
it's
something.
one thing to be receptive. Have you discerned any tangible improvements on the part of the PCO since your meeting?
It is still very difficult.
So the answer to that, I would take it, is no.
No.
Okay.
Okay, thank you, Mr. Cooper. Ms. Church for 5 minutes. Go ahead.
Thank you very much, Mr. Chair. Ms. Maynard, just picking up on this about PCO, I think you mentioned in your opening remarks the historic age range of time that PCO often deals with in terms of the requests that they're receiving. Could you just clarify for me what were those age range that you mentioned? Was it 35 to 60?
Yeah, something like that.
So just so that I'm clear, was your comment then that one of the major issues that PCO has to grapple with is the fact that these requests often touch records that are 35 to 60 years old? in
Documents.
documents. Are those documents digitized, or are they still in pre-digital paper form? How are they stored?
They are mainly paper.
They're mainly paper, so they're not even housed. They'd be housed somewhere in storage
Nope. They're in their storage at PCO.
in PCO. Is there a moment in time when records of a historical nature like that are dating? I mean, 60 years. I'm trying to do the math here. It's taking us back to the 1960s. Do those records ever move over to Library and Archives to be archived?
It goes back to the
historical?
authority of each institution to determine when they will send the documents that Library and Archives and the institutions agree that they are archival value to Library and Archives. So it would be a really good question to ask Mrs. Weir or somebody from PCO, why are these documents still within PCO?
Is that practice common to other departments as well, that they would be holding on to records, or could be? I guess the idea is that they could be holding on to records of that age.
We don't see that very often. PCO is definitely the institution that has the oldest, I would say, records that are being asked by requesters.
Right. So what are some of the recommendations you might have? Because I think that's a very different problem, in fact, actually, to be looking at records that are pre-digital, that are from mid-last century versus records that we're generating in government today. What are some of the ways that we should be looking at that, or that we could address that challenge in government?
It is, as any other institutions, one, you have to determine when your documents will be destroyed, the periods, and if not, when are they going to be transferred to Library and Archives? And that discussion has to be happening with Library and Archives.
Right. And presumably at a time that would make sense, maybe at a change of government, for example, or when your government, when you are doing an assessment of your records and you're doing that assessment of what needs to be archived.
Every year you should be doing some cleaning up.
Or
of
every
your,
year, but certainly at the end, but certainly, no, I'm
But
with you
now
there.
we're dealing with older, yes.
Can you, and my colleague asked just a little bit about this, about artificial intelligence, about technological solutions. I'm just wondering, are there any technical tools that exist currently that would help people who are working in the system designate an email as a record for retention? You've mentioned the challenge that we see from duplication, from email threads, where there can be many people in an email, and the question is who retains it for the purposes of record keeping. Are there tools that make that process easier? We all manage inboxes today. They are often a source of, a daily waterfall of electronic information. What exists there to make this process easier for public servants and political actors who are working in the system?
I am not aware of a tool that does that right now for somebody's own email and inbox, and that would be a great tool if that was to exist.
So it's very much on the individual to figure out the best possible and personal system of record keeping and archiving.
Yeah, it is within the institution that there have to be rules about who keeps what and how long and where.
Right. And when my colleague was asking you a little bit about artificial intelligence, and you mentioned a few of the departments that are using AI, are there any of them that are using this creatively now in terms of how to keep these records or how to search and accumulate these records?
I'm aware of Transport Canada, who's been testing some AI with respect to their access to information system and processes. IRCC as well. In New Zealand, the access requests are being processed initially by AI to triage and then to find the information. But to do that, you have to have proper information management to start with.
To begin with, so that you're collecting the right records.
All right.
Thank you.
Thank you, Ms. Church. Commissioner, Monsieur Thériault, 5 minutes.
Thank you, Chair. A few people have stated that exceptions to the legislation should be very limited. There should be a harms test, or we need to show why it would be an impact, there would be an impact on the public, and that all documents should be made public after 20 years. I believe that the current exemptions should be reviewed, analyzed to ensure that they limit access to information as little as possible. There should be shorter time frames. And for the last 40 years, there haven't been any amendments to these exemptions. 1993, I believe, so 43 years. Earlier, you said that public institutions should be covered by the legislation. There's an organization that has said for public institutions there should be detailed information on decisions made, and so a duty to document. You mentioned that earlier, and I would like to hear you say more. The duty to document is that there's no response to an access to information request if a document was not created on a decision made or actions taken. In Canada, there's only BC that has an obligation to document. This requires some extra effort for its application, but it does support access to information. I think that this is something that should be considered, whether it be in our legislation or in archives or information management. There should be some kind of obligation, just as there is for financial transactions, performance documents. We should have a similar reflex for all government decisions. Is this something that is currently done in institutions that are subject to the legislation? Have you had any good experiences with that duty to document? I would say that there are currently too many documents, but not enough that are relevant. There's a lot of back and forth of transitory records. We need to find the relevant information, and so there needs to be an obligation to document decisions, as you mentioned, and it needs to be in a specific document that would be easier for people to find that information. There can't be access to information if the information is hidden in a forest, whereas it could be found in a hut in a very specific area in that forest. So, it could be done, but by sending out a bunch of information, it could be a way to hide information as well. It's because of how people work nowadays. We work more quickly, we do more with less. There's less accountability for public service employees. They're asked to do a lot of things very quickly, and so that is an issue as well. A training issue. Training and understanding their responsibilities and to clean up files. There was another interesting recommendation. Oh, Mr. Thériault, Apologies, your time is up. Maybe Mr. Hardy will be able to ask your question for you. Mr. Hardy, you can speak with Mr. Thériault if you'd like. Thank you, Ms. Maynard, for being with us today. The Prime Minister, during the previous election campaign, stated that it's very important to have access to information in order to reassure Canadians, of course, but you're saying that the current system is not meeting its initial goal. So I'm seeing a contradiction by saying that it's important while also having a system that does not support access to information. Do you feel supported and respected in your work, Ms. Maynard? I would say that I have the tools that I need to do my job, but do institutions have the resources and the support? I can't say that. And with cuts that are coming up, I am concerned. What is your current operational budget if we look at the evolution of the task? What is the budget allocated for access to information annually? My budget is about 15 million a year. For the powers that you have regarding ordering access to information, if the government decides not to do that, I imagine there will be a cost to taxpayers. You'll have to go to court. Is this something that happens? We're talking about two things there. During my investigations, I can force institutions to give me the information that I need for the investigation. Currently, I haven't had to go to court for that. When my investigation is concluded and I send out an order, they can respect it or they can go to court, and they're the ones who have to go to court, and that is included in the legislation. We've got 11 files ongoing. 11. How much did that cost to taxpayers for your office and for the government to fight your decision? Well, they're fighting the order, of course. I think I said this last week in community. There are about 3 employees, lawyers who are experts. We need that expertise. So 2 additional salaries, maybe? 1.6 million that the government had spent to fight your orders. Is that correct? I think that was in the last 4 years. That's what the government had spent in a lawyer's fees. So, in order to contest what you've said regarding the access to information request, so that costs taxpayers, and they had to pay for salaries for your office to ensure the protection of the access to information, but they're spending additional funds in order to contest an order following one of your investigations. Yes, the government can go to court and ask for additional time to answer a request. Do you feel that Quebecers and Canadians nowadays have access to information as they should regarding what's happening in the government apparatus? Do you believe that access is the same if we talk about 10 years ago and today? Is access similar? Do people have less access than before? I believe that you may have mentioned it earlier. Not having access to information leads to cynicism. I think that there are so many ways to get access to information, and so people don't know what to believe, what's reliable information, what is true. That's why access to information and proactive disclosure needs to be increased so that they have access to this information before they have to look elsewhere and have access to data that might not be reliable. There are more requests. We're talking about 220,000 requests per year. It increased by 110%. Are they receiving that information in a timely manner? Can they trust the information? These are all questions that have an impact on public trust. So if we want to go with what the Prime Minister said, and that it's important, Well, your office then should be receiving more funding to support access to information. Especially when somebody's making requests, the information needs to be easier to find, and that would reduce the cynicism, and your office would be able to give out more reliable information than what can be found online. I believe I still have a bit of time left. I was on a roll. Oh, maybe not. Unfortunately, your time is up. But before I give the floor to Ms. Lapointe, we'll have one more 5-minute round for the Conservatives and the Liberals after Ms. Lapointe, and perhaps we could give 2.5 minutes to Mr. Thériault, and we'll conclude after that. Ms. Lapointe, you have 5 minutes. Thank you, Chair. This is not your first time at committee, of course. I would like to come back to what Mr. Hardy said. He asked you about your $15 million budget. You mentioned that your resources will not be cut. Have you discussed with institutions whether or not their access to information departments will have reduced resources? I was going to respond to Mr. Hardy that I shouldn't be receiving more resources. It's really institutions that should not make those cuts to their access to information teams, because that's where Canadians can go for information. You can ask this question to Ms. Weir from Library and Archives Canada. She told me that her budget will be cut by $15 million for access to information. That's 7.5%. That's the same as the entirety of my budget for my office. And that's one example among many others. I hadn't understood that. But I'll come back to something else. Earlier, you talked about emails and inboxes. You also mentioned New Zealand. You stated that there are no tools available and that there should be rules. When you talk about cleaning up one's inbox, there are things that have been ongoing for a while, and are there no guidelines on that? You mentioned New Zealand. Our inboxes, well, we don't necessarily know how to manage them, and you mentioned that somebody should be responsible for that. Has anyone looked into that issue, and could they help us understand what we need to keep or delete in our inbox? What do you have to say? My office published a document on how to manage your inboxes. This comes from our office because we saw a need for it. But Treasury Board and people who are responsible for information management should ensure that everyone has the tools to understand what needs to be kept in an inbox. And I understand it's very difficult. Often we have half days where we have people ask themselves questions. We ask them to sort in their inbox. If it's a decision, it needs to be put in a certain file. These documents are kept if they are of value, but they need to be saved in files for that. But again, it's up to the institution or the agency to determine those rules. Are there tools? Probably. I'm not aware of them. But it's coming. There are likely tools that can help you or understand what is duplicated in your inbox. How many times do you send an email saying thank you? And that's it. That's all that's in the email. If I could just erase all of those thank yous, that would be an example of a transitory record that doesn't need to be kept. I agree. and we are submerged. You mentioned BC earlier, that they have an obligation to support access to information. Can you tell us for BC if that's led to better results? Are people receiving access in a more timely manner? In 30 seconds, please. Yes and no. I think that it forces people to ask themselves questions because they have an obligation, but it also creates a situation where they keep everything, and so we end up with too many documents. So there are issues on both ends. Thank you, Ms. Lapointe. 5 minutes. Mr. Hardy shared with Mr. Cooper, and I will let you know when you're at 2 minutes, 30 seconds. Mr. Hardy. Thank you. A simple question. We saw some departments use automatic suppression for Teams 15 days, email 30 days. There's legislation 67 for access to information. It's a 3-in-1. Does it go against that article? No. Is it a risk to the access to information in your view? And were you consulted for departments to decide that 15 and 30 days for automatic deletion? We were not consulted because these come from Treasury Board and Library and Archives. This is not something that ends up on my desk unless there's an access to information request. There should be a process if there's something on Teams where it would stop the automatic deletion because there's a request made. If you erase something knowing that there's an access to information request, that's where one can state that something criminal happened. Maybe it would be great if they consulted you first to see whether or not they were causing a problem. Wouldn't that be the best first step? Again, that was not from us, but I did send a letter. I sent it to you last week with some guiding principles that I believe that institutions should follow in making such decisions. Thank you. Mr. Cooper.
Thank you, Mr. Chair. Commissioner, last September, a discussion paper from Treasury Board, which is responsible for setting access to information policies, suggested that the government may need to, quote, revisit your order-making powers. The discussion paper states that your order-making powers are, quote, meant to be a measure of last resort, but their use has steadily increased, end of quote. The implication appears to be that somehow you're abusing your order-making powers. It seems to me the Treasury Board and this government have it exactly backwards. The problem is not that you are exercising your order-making powers more frequently. The problem is a steady deterioration in the access to information system across government that has made it necessary for you to issue such orders to direct government departments and institutions to follow the law. Is that fair?
I agree with your statement.
Okay. Now, your office issued a statement in December 2025 following this discussion paper from this government stating that, quote, any revisiting of order-making power that resulted in a scaling back of this power would represent a step backward for the access to information system. Can you elaborate on to what degree it would be a step backwards and the negative impact that it would have on Canadians' ability to access information from this government or federal government generally?
The order-making power allows me to stop investigations from going forever. So we are doing our job to make sure that requesters receive a response to their access requests in as quickly as possible. And there's a lot of discussions with parties, with the requesters, and as well with the institution. But if you don't have a way to stop that, at one point, something needs to be done. So we try to settle everything or to conclude the investigation as informally as possible, but sometimes we have no choice, and the institutions has to know there's a date by which they have to answer the requester, and those orders are necessary for that.
There was this discussion paper. You said you've heard generally that there is consideration of rolling back your powers, important powers that Parliament gave you. Have you heard anything more on that front? Have
No.
you had any discussions?
I've sent 2 letters to the President of Treasury Board to ask when will the review start, and I'm waiting, as anybody else, to be consulted and to have my chance to make submissions with respect to whatever paper or policies or recommendations
Right,
the
and with
government.
respect to those letters, you sent one in June of 25 and another in January of 26. Is that right?
That's right.
And your letters have not been responded to by
No.
the President of Treasury Board. No communication whatsoever with President
No.
of Treasury Board. Astounding.
Okay, thank you, Mr. Cooper. Mr. Saini, for 5 minutes, please go ahead.
In 2019, you were given the powers to order stuff.
Yes.
When you compare those powers to the other Western countries, New Zealand, Australia, Britain, where are we comparatively?
We're very similar to Australia, to the UK, Scotland. We're even internal in Canada. You have authorities that have the issues to the authority to issue orders, like British Columbia, Ontario, and then you have other jurisdictions that are still only able to issue recommendations.
How do you consider our overall access to information laws, which you're responsible for implementing, compared to the other countries also?
Well,
Do they need some improvement?
we do need to improve the law, but I think we're 52 with respect to our legislations, in considering the law itself, but we need to definitely open up. Like I said earlier, the Act is about 42 years old, and in 2019, as you mentioned, the authority to issue orders was given to me. That was a major amendment, and very appreciative of it. But nothing else really in the Act was looked at, and that's where we are at now.
You have also wanted that the PMO and Minister's Office access be granted. The controversy that we have seen recently in Ontario, what is your view? Is that going to make it better, or this is what's happening in Ontario is going to become a normal?
Well, access to information is there to make our government accountable and for Canadians to understand what's going on. So I think this is the right thing to do. In Ontario, the offices of the ministers and the Prime Minister, the Premier, are subjected to the Act, and in Canada, we're not. We don't have that. So I think that the Act has to be amended to make sure that the people working and have been elected by Canadians are accountable as well for the decisions and the actions and the communication that they have within their office.
Thank you. The $5 fee, how has that helped an average citizen to get access?
It's a very low fee. It's one of the lowest in Canada. Sometimes I'm wondering why have a fee, because it's probably more expensive to administer the fee than it actually cost, like to recover. In my office, for example, we don't charge the $5 because we realized it was more work to administer a $5 fee, but it is probably sufficiently and it's good enough for people to think about it when they make an access request. Whether it's sufficient or not sufficient, that's something I think you have to ask the Treasury Board, but access to information should be free. So $5 is pretty close. In BC, it's $25 now to make an access request.
Okay. I don't have any.
A minute,
Oui,
30 secondes.
On a parlé un peu plus tôt du plan.
Earlier, we talked about an upcoming action plan. the Treasury Board Secretariat created an action plan, I believe, and there will be a modernization on access to information. There's information on measures up until now and results. In 2020, the legislation was supposed to be reviewed by Parliament, and your committee studied the legislation in 2022. It was not a review, an exhaustive review of the legislation. Things were done regarding the access to information system. I haven't seen an update since 2024 on that action plan, and in 2025, a legislative review was announced by Treasury Board, but again, we're still waiting for this legislative review. Another question on those 47 measures in the plan, have any been completed? You'd have to verify that with Treasury Board because it is their action plan. To my knowledge, the plan includes certain amendments, but we're talking about the whole system here, and there haven't been many changes. Thank you. Mr. Thériault, we're going to conclude with you with a brief question and answer. It seems that there has been an increase in requests that receive an empty answer. 28% of these responses were empty. So they're responding, but they're not responding with anything of substance. So these empty answers, are they counted in the requests that the government deems answered? Should there be consequences in such cases? There are different factors, but there can be a complaint if ever people believe that there should be information and they haven't received anything. But sometimes a request was sent to the wrong place, and that's something that we can confirm. Sometimes they haven't discussed with the institution to see how to make the request. Sometimes how the request was made led to that kind of response, and an investigation would be able to clear all that up. If it leads to existing information that that person should have received, there currently aren't any sanctions, but I just have to say that they have to give the information. Can you sanction an institution? I think that would be difficult. There should be measures for performance so that people who are responsible for access and for giving information, because it's not often the information team, it's another team, and so they need to be assessed regarding access to information and the responses that they give to those requests. Thank you, Mr. Thériault. Thank you, Ms. Maynard.
Taking the time to be with us today, such short notice. I know that there's been a lot of attention to the issue of access to information over the last several years, and so you being here today has helped us in regards to our study. We were supposed to have Ms. Weir here today for the second hour. Unfortunately, she wasn't available. But we're trying to get here, I think, Thursday with the Treasury Board Secretariat and representatives from the Privy Council office as well. So thank you again, Commissioner. We're going to move on to some committee business. So I'm going to excuse you and thank you again for your time. There's a couple of things that I need to deal with. Two study budgets. One on this study, upwards of $2,500, and you can tell by the refreshments in the back that I don't expect that we're going to be spending much money on this study, but it's up to $2,500, so I need approval from the committee on that. Do I have approval? Yes? Yes? And the second one is a supplementary study budget, which is the order of reference from the House to add meetings to the Review of Conflict of Interest Act. The supplementary amount requested is for $2,000. Do I have consensus on that. Okay, I do. Thank you so much. I also understand, too, that the House leaders will be discussing tomorrow the unanimous consent motion that's required for us to proceed to our study for the Lobbying Act, the review of the Lobbying Act. So I'm looking forward to that. Thank you for making that possible. And the other one that I need to deal with is a routine motion regarding distribution and access to documents to 3 associate members per recognized parties. This is something that's happening across all committees. It's a routine motion. I understand that Mr. Cooper has the motion to present to the committee, and I'm going to invite Mr. Cooper to read out the motion now.
Thank you, Mr. Chair. On this matter of housekeeping business, I move the following motion that, notwithstanding the usual practices of the committee concerning access to and distribution of documents, A, up to 3 associate members of the committee per party be authorized to receive the notices of meetings and notices of motion and be granted access to the digital binder. B, that the associate members be designated by the offices of the whips of each recognized party and sent to the committee clerk. And C, that the provisions of this motion expire as of Friday, September 25th, 2026, unless otherwise ordered.
Thank you, Mr. Cooper. I'm just going to confirm with the clerk that that is the standard item motion. No changes at all. It is. Any discussion on that? No? Do I have approval from the committee on that? Okay, I do. Thank you, members. I don't have any other Ms. Church.
Mr. Chair, would you just give us a little bit of maybe a rundown of what you expect in terms of committee business for the next couple of weeks?
Okay, so as I mentioned earlier, we're trying to get the Library and Archives, Ms. Weir here Thursday, Treasury Board Secretariat, plus the PCO. My expectation is that we're going to commence the draft report of the Conflict of Interest study next Monday, and likely, unless of course members are in agreement and amendments are possible. We understand all of that. The plan is for at least 2 days next week to have that study in its draft form to.
The week after.
Oh, sorry, not next week, the week after. And thank you for clearing that. Yeah. I have no plans on coming in on my off time for that. So that'll be the week following the Family Day week, and then we're planning on 2 meetings. If we are able to get through that, then my plan is to commence the lobbying study as soon as possible. Okay. As far as the AI study is concerned, I mean, we're at the max in terms of having the minister in, as we did last week. I don't expect that we're going to. We've had requests for witnesses, and my offer to them have been to supply briefs because we can't keep having meetings about that. Considering the motion, I forget how many meetings we're allowed up to 4, I think. The motion read, maybe more. We've had more meetings than that. So that's the plan. But the plan is to, after we get through the draft report on the Conflict of Interest study, then we're going to get into the Lobbying Act. Okay? So does that answer your question? Good. No other business? No other questions? Okay. I'm going to adjourn the meeting. Thank you, everyone.